So welcome everybody. We're so glad you could make it tonight. We've got a wonderful presentation on the history of voting rights, and we'd like to encourage all the students out there to join the Purdue Law Society. We're very proud of our organization, and we have another fabulous presentation coming up on October 22nd about AI, and it's called "Are We Even Here?" So hopefully you all can, y'all, to use my Kentucky drawl, can show up for that one. Our presenters this evening are some wonderful professors, colleagues of mine and friends as well. John Berube and Karla Brenner and Jane McElligott are going to do the presentation. I'm not going to take up any more time. I'm going to go ahead and let them start, and I'll turn off my camera, and away we go.
Well, I will be starting it off here. I'll start with the early history, and I first want to thank Said for that inspiring music. I feel psyched to go. So if we could start with the next slide. So just an overview of the history that I'll cover in 15 minutes. So it's interesting to look at, during what's called the radical Reconstruction after the Civil War. Voting rights were actually getting pretty powerful. This was after the passage of the 13th, 14th, and 15th Amendments. Um, but then things were shut down pretty quickly. There was about a span of 10 years or so that things were looking good, but it didn't last too long. So we'll just take a look at how that denial of the right to vote started coming into play, how it then improved again after the passage of the Voting Rights Act of 1965, but then the Supreme Court SCOTUS struck down some key provisions of the Voting Rights Act, and leading to what we have today, quite a good, much better than it used to be on voting rights, but still a lot of issues to overcome. So if we can go to the next slide. Another little overview, a famous quote from Frederick Douglass, speaking to how important, the institution of slavery had been ended, but not until the ballot was available for the recently, those who are recently placed into freedom could actual rights come about. So we'll take a look at the Civil War amendments, Reconstruction era, go up to Selma and the Voting Rights Act, and unfortunately Shelby County versus Holder. So next slide. So these are the Civil War amendments, and for students, you probably have covered these in your classes, but the 13th Amendment was the one that ended the institution of slavery. 14th Amendment is the key provision that provides equal protection, due process. It also overturned the horrible Dred Scott decision, so ensuring that African American individuals did have citizenship rights. The 15th Amendment was the powerful amendment relating to voting that prohibited the states from denying the right to vote based on race. However, the states soon found other ways. Well, technically, the denial was not based on race. They brought in poll taxes, literacy tests, and not to mention intimidation, violence as well. This is a very famous picture from Harper's Weekly back in I think the date was 1870. Oh, I had it written down, 1870. I'm sorry, 1867. So this was the first vote for African American individuals. So powerful photo there, or portrait, I should say. So radical Reconstruction, this happened after the Civil War had ended, and there was, of course, a strong need that the southern states still, they were still trying to secede from the nation. The answer was to send in troops, federal troops. These southern states were divided into military zones, basically. And as you can see there, that's another famous picture from Harper's Weekly, showing the Freedmen's Bureau and the power they had to protect those who had been, recently freed, and enable them to be able to vote and exercise their other constitutional rights. So each state, as a requirement of radical Reconstruction, each state had to form a new constitution, have new elections. The freedmen could now vote, run for office, and on the other hand, the former Confederates could not run for office. So it was really starting to set forth a fair playing ground. The states were required to ratify the 14th Amendment in order to be readmitted to the Union. Next slide. As we will see in this whole progression of history, education is always so much tied in with the right to vote. And once the right to vote came about, freedmen's schools started being formed. And a lot of it was funded by the Freedmen's Bureau, but also missionaries. Freedmen and the freed women themselves were really the main uh, um, advocates who got the freedmen schools going. And so these schools started flourishing in the South because it was a powerful way for those who, were just starting to be able to exercise their constitutional rights, their civil rights, to be able to, learn about the laws, citizenship, and all of the important things they wanted to learn so that they could exercise their new rights of citizenship. And that again is a photo from Harper's Weekly. Next slide, please. So during this time, this 1867 to 1877, during this radical Reconstruction, it was amazing the progress that had been made, going from no right to vote based on race to 16 Black men were elected to Congress. 600 Black men were elected to Southern state legislatures. So 2,000 Black men were elected to public office. And keep in mind that we're talking about a move to racial equality, but not gender equality at this time. The right to vote for women was not until 1920. So still a long way to go there. In 1877, Reconstruction, unfortunately, was put to the side. More time was needed to truly bring about citizenship and equality. But the radical Republicans, they fell out of power to basically a white supremacist wing of the Democrats. And the Southern states quickly got into office. They began putting strict measures into place to really limit the right to vote for Black men, even though it had just recently been won. So they used poll taxes, literacy tests, all white primaries, felony disenfranchisement laws, grandfather clauses, which we'll talk about in a second, fraud and outright intimidation. Intimidation in the sense that, once the institution of slavery ended, a lot of African Americans were sharecroppers. And so the ones sort of in charge of these sharecropping places would say to any African American who's about to go vote, well, if you go vote or if you go register to vote, I'm evicting you. So I mean, that kind of pressure and intimidation was just enough to start suppressing, understandably, to suppress the vote. Next slide, please. So this isn't just one example. This is Louisiana's literacy test. And, you would think when you hear literacy test, oh, it just means it's testing to see if you can read and write. No, this test is ridiculous. This test is harder than a bar exam. And in fact, these academics in political science took the test and many could not pass. I know the writing is little, but if, for example, you look at number 10, in the first circle below, write the last letter of the first word beginning with L. You look at it and you go, huh? And keep in mind too, or number 20, spell backwards forwards. And I won't even read number 22 and 23, but they're long, convoluted, and these tests were timed. And the people who administered the tests were, not surprisingly, white people, the white administrators who could decide if someone passed or didn't pass. They were just shockingly, horribly difficult to pass. And if you can go to the next slide. I don't know if there were even right answers on these. Next next slide, please. Oh, there we go. So yeah, and in this one, yeah, this number 29 really stood out to me. Well, no, actually, I think 28 is worse. Divide a vertical line in two equal parts by bisecting it with a curved horizontal line that is only straight in spot in the spot direction of you just look at it and go, what is that even saying? Right, exactly, Clyde. If there were right answers, you'd never know it because they wouldn't be graded that way. Exactly. So and of course, so the literacy tests were only pretty much given to the Black voters because of grandfathering. So if a person's grandfather was did not have to take a literacy test, um, and they had voted, then they wouldn't have to take the literacy test. So basically, it was saying that white people don't have to take the literacy test. So everything was just as bad as in no time after radical reconstruction ended. It's just they're not using the word race, so they're totally getting around the 15th Amendment. So next slide, please. So here is a little more on the grandfather clause, which you probably have heard of. So the technical meaning of it is that it was the 15th Amendment prohibited states from passing laws saying Black people could not vote, which is what we're just saying. But the thing is, and Southern states probably wanted to do just that. But the amendment said nothing about non-racial restrictions. So that's where all these measures cropped up. Literacy tests, poll taxes, were just a way to make it so white people can go in and vote with no problem. Black people have huge barriers to overcome. And Southern states enacted these grandfather clauses, and they provided a waiver for poll taxes, for literacy tests, for men whose fathers or grandfathers could vote before 1867. So you can see exactly the reasoning, or not the reasoning, but the tactic that they're using there to really set up a completely unfair playing ground when it comes to voting. Um, and and next slide, please. So again, we see this education come into play. So now it was the citizenship schools, and Septima Clark, who you may have heard of because she's a big civil rights advocate, but she is actually titled the mother of the civil rights movement by Dr. King. She founded citizenship schools, and they were kind of a follow-up to the earlier Freedmen Bureau's schools, and they transformed the South by increasing the number of African Americans who could vote. So if the plan really, if they're going to have these crazy literacy tests, then we're going to have schools and we can teach people how to overcome these literacy tests. And that's exactly what happened. So Andrew Young described, another civil rights leader, described the key role of citizenship schools as laying the foundation for all that was to follow in the civil rights movement. Because without that right to vote, the civil rights movement would not have gained momentum. And next slide, please. And they were also still called freedom schools at times, but I love this quote because it points out that education should enable children to possess their own lives instead of living at the mercy of others. And that was really the whole goal of the freedmen and then later the citizenship schools. Next slide, please. And so this leads, we kind of skipped over many years, and I will speed it up because I don't want to take too much time on this, but civil rights leader John Lewis, as we still hear of, a remarkable advocate of civil rights his whole life. This is a picture of him going over the Edmund Pettus Bridge. If you haven't seen the movie Selma, it's an amazingly good movie, and it shows this whole the brutal attack by oncoming state troopers of the protesters who were simply trying to get the right to vote, and that was called Bloody Sunday. Next slide, please. And so John Lewis, there's a picture of him actually being beaten. He was so injured from that. I mean, as you can see, the powerful club there being hitting his skull, that they feared that he wouldn't survive, but he did, and he went on to just be a lifelong advocate for voting rights. And this was the thing about this was it was shown um, uh, on nationwide on TV, and it got people to recognize that this isn't right. This isn't what we want to see on the news that is happening in our own country. So it really kind of got the public behind voting rights and wanting to see change, a positive change. Next slide, please. And so that did help President Johnson sign the Voting Rights Act in August of 1965. And he said it is wrong, deadly wrong, to deny any of your fellow Americans the right to vote in this country. So the time had come. Next slide, please. So the Voting Rights Act, um, it was a powerful act because it banned the literacy test, the grandfather clause, all of these impediments to voting. And Section 5 was another powerful measure that mandated pre-clearance for states. So states that had this history of discrimination, if they wanted to change their laws, they had to get pre-clearance from the federal government. Next slide, please. Uh, and so that was a good measure to prevent discrimination. Just to mention there, the 24th Amendment came into play to end poll taxes. The Voting Rights Act itself didn't address that, but poll taxes too was struck down. So next slide. So that's when SCOTUS Supreme Court came in and sadly annihilated the Voting Rights Act of 1965. It got rid of the federal pre-clearance, which again was a powerful way to stop measures that restricted voting. So in Shelby, SCOTUS gave the states with these records, again, blatant voter suppression, pretty much the stamp of approval to go right back to the discriminatory ways, and they did not waste any time. Texas passed rules requiring a state-issued photo ID to vote just within days of this decision, so it was a huge setback to voting rights. Next slide, please. And so this is a famous quote from Justice Ginsburg, who we all love and miss, but she said that throwing out the Voting Rights Act when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet, which I think just describes it perfectly. And next slide, I think that may be where I hand it over to John. Thank you.
Hi there. Thanks, Jane, so much for that wonderful introduction that got us going, learning about the history. For part two, I'm going to look at Shelby and beyond. So the destruction of the Voting Rights Act really led to an avalanche of statutory barriers. Jane just began to introduce that. I'm also going to weave in the issue of the criminal law aspects of voter suppression, which, again, Jane hinted at earlier. That was part of the ways that they would place barriers to voting rights back in the day, and it came back to pass. And this, I think, will hopefully set a really clear stage for us to evaluate Georgia as a battleground state, which is where Karla will take over the presentation. Next slide. Okay, there we go. I'm having a hard time getting the next slide for me. That's not good. As Jane was indicating, the Supreme Court, Chief Justice Roberts wrote the opinion in Shelby County. In his 2013 opinion, he said, "Our country has changed." But as Jane pointed out, just in her introductory remarks, it really hadn't. And if anybody looks at what has happened since 2013, it is clear that there have been effort upon effort upon effort by many states in order to, again, raise these barriers to the voting rights. If we look just at what happened at the beginning of last year, 2013, 11 states enacted 15 restrictive laws. 4 other states enacted 5 different election interference laws, which again are barriers. And then 13 states enacted 19 expansive laws. I suppose if one were to look at 2023 somewhat objectively, you can see some positive and some negative movement, but again, the positive movement is happening in states where the voting rights are not being suppressed. They're doing things to improve upon voter outreach, but we're still seeing a clear negative move by many states. And as Jane pointed out, if you look back to 2014, the year right after it passed, 22 states adopted voting legislation that restricted access. Immediately after the 2020 elections, between January 1st and July 14th of 2021, 18 states had enacted 30 new laws that again restricted people's rights to vote. More than 400 bills with restrictive provision had been introduced during that time period in 49 different states. It's clear that the goal of all of this was to raise barriers. And the only reason they could do that for many of them is because of because of Shelby County. And if we look historically over the past 10 plus years since the Shelby case was decided, there has been consistent efforts every year. And per Singh and Carter, almost 100 laws have been enacted since Shelby County that have deterred voters, have prevented them from using their constitutional right to vote. 11 states in particular have enacted many of these provisions and these 11 states were under the pre-clearance rules, the rules that Jane introduced with the Voters' Rights Act. So those states, if you go back to the slide, I think it's slide 16, the states rather that were in the dark red, the entire state had to get any approval of changes to the laws approved by the federal government, either through courts or the DOJ, if I remember correctly. The other states, there were either counties or townships that were under the restrictions of the pre-clearance. And again, Alabama, Arizona, Florida, I'm not going to read all of the names on the slide, but those states were under the pre-clearance rules. They now didn't have to follow any of those rules. New York passed one or two restrictive provisions, but they also passed provisions that expanded voting rights. So again, if it was a mix, if it was correcting some perceived problems, but overall expanding the rights to vote, maybe Justice Roberts might have gotten it right. However, most of these rules were to restrict access. Primary targets of suppression were voter IDs and restriction on mail-in ballots, which we saw were so effective in 2020. That was probably the most, the election that had the most votes cast ever. Just because some people didn't like the outcome doesn't mean that the process failed. And so that is where we see the problems. They're starting to raise these barriers to voting. Some of these laws also led to challenges, court challenges. One of the more well-known ones that went all the way up to the Supreme Court was Brnovich versus the DNC, where Arizona had criminalized third parties bringing ballots to the election offices, legitimately cast. No problems with it. They just didn't want third parties to be carrying them because of the potential, they argued, for tampering, which there was no evidence to suggest that ever occurred. They also had this issue with vote centers versus precinct-based systems. 90% of the state used the precinct-based system, and the issue was there, if somebody went to the wrong precinct, they could cast a provisional ballot. But if you went to the wrong precinct, even if you could vote for president, governor, any of the major contests on the ballot, you were registered to vote. You could vote for those particular things in your state. Because you went to the wrong precinct, they would throw everything out. And the Supreme Court deemed that these laws were not discriminatory. They were perfectly constitutional under the VWA. And again, who has a more difficult time getting to the proper precinct? Who has the more convenient precincts? These are all issues that they did not want to look at or address, because that is the underlying issue. And so that they were throwing all these barriers up. And again, I think most people who look at what has happened since then would argue Chief Justice was wrong. When given the opportunity to place these barriers, significant numbers of states, those who were required to follow the pre-clearance procedures prior to Shelby, didn't have to, and they went with full force to try and reinstall these barriers. The community really has not changed, and I think it's pretty straightforward from the evidence we've seen. I'm going to now touch upon voting rights and the criminal justice process. Felons, once they've been convicted, lose their right to vote. And I think most people agree that that is not something that is completely offensive to our thoughts of what is right or just and constitutional provisions. Only 3 states have, or jurisdictions, DC, Maine, and Vermont, have said that felons will never lose their right to vote. But the other 3 categories shows that felons can lose their right to vote. There's automatic restatement in 23 states. That is up from, I think, 21, which was within the last 2 years or so. So we're seeing more states move towards automatic reinstatement. There is continued limitation in 15 states. This is a little bit of an improvement that it's down from 16. And we see states like Alaska, Arkansas, and so forth, where there's some continued limitations, but they can still get reinstatement down the road. And it's pretty straightforward and clear. The additional burdens are on the 10 states at the far right. Again, a slight improvement. One of them is shifted up. We're down to 10 states, but these are the states where we have the biggest burdens. Florida is going to be a talking point for me in a moment. If we look at the recent trends in this area, we have seen some general improvements, increasing the access to vote. DC, as we just saw, recently added themselves to the first column where those incarcerated don't lose their right. We've seen improvements in Connecticut, New York, Washington State, California, granted parole. Once they're granted parole, they get the right to vote immediately. A few states have also moved for automatic reinstatements. Even some of the states that have restrictive laws, there's been some improvements a little bit. Alabama, those who've been convicted of felonies for moral turpitude or suffering mental infirmity, they don't get their rights back. They finally in 2017 defined what moral turpitude is, which is a positive, because when these terms are not defined, then there's much more wiggle room for discrimination. Delaware, there's some positive changes there as well. With Iowa, it depends on who the governor is. Depending upon the governor, it's whether or not a felon gets their rights back is all tied into the governor allowing the rights to be returned to them. So it depends upon who is in the governor's office. Currently, Governor Kim Reynolds, a Republican, has been good in continuing the ability of felons to regain their rights. So there has been there's some good and some bad, but generally speaking, there's a lot of problems here. I want to talk a little bit about Florida because that's really a prime example of what's going wrong. The voters in Florida, and I live in Florida, some of you may live in Florida as well, 2018 voted on an amendment to allow greater access for felons to regain the right to vote. It passed by the supermajority, over 60%, if I'm remembering correctly, that had to vote in favor of it. It did, it passed, and then the legislature, and then signed by the governor, sought to define what the process would look like. They added in all sorts of regulations, rules, requirements that were not mentioned or part of the ballot initiative, and made things more difficult. The interim motions and arguments, there was, of course, a federal case filed. Those interim motions and arguments were ruled against the state time and time again. Unfortunately, the 11th Circuit, they were asked to rule en banc, meaning that the entire 11th Circuit had to rule. There was a panel of 3 from the 11th Circuit that ruled in favor of, or rather against the state, in favor of the petitioners. The full 11th Circuit found the provision to be constitutional. They said, it doesn't matter if it's not very clear to the felons who've been released, as long as there is a process and there is some chance at some point down the road that they will ultimately jump through all the hoops and get their voting rights back, then that is constitutional. And I don't think that really sounds very constitutional to me personally. That's a personal comment all on its own, but it's clearly showing that we don't mind those barriers. Or at least the 11th Circuit didn't. Florida law does result in greater disenfranchisement of minorities, particularly African Americans. If you just look at the criminal justice process, that in and of itself would be another hour-long presentation at least. That is the problem with this type of policy of disenfranchising felons, because the criminal justice system does work against minorities in this country. One must take full stake, must have a full stake in the community to feel part of it. This really goes back to the quote that Jane shared with us earlier from Frederick Douglass, in my mind, where if you're not really part of the community, or you don't feel part of the community if you don't have the right to vote. The right to vote is essential to citizenship, and there's a clear relationship between disenfranchisement and recidivism. The article that I cite, Hamilton, Smith, and Vogel, shows this clear relationship. So if you don't feel connected to the community, if you've not regained the right to vote, if you don't have a say, then you're not going to feel that connection, and you will likely just repeat your offenses. And not only that, the disparity in the punishment for those who don't understand the rules, who don't follow them, and this is not just Florida, so now we're expanding beyond the state of Florida. I'm not going to read this whole slide, but the first three individuals, Pamela Moss, Crystal Mason, and Purvis Rogers, were African American. They were felons. They were not clearly told, or did not clearly understand their rights upon release in terms of voting. In some cases, they may have asked people and they got misinformation. They cast provisional ballots or tried to vote. Purvis voted in a Democratic primary, not even an actual election, and they were all charged with felony crimes. Most of the convictions were overturned. Crystal Mason, though, her conviction was overturned, but they are now currently appealing to the highest state court to reconsider. Whereas the three men in the final bullet, Bartman, Hartle, and Thurman, were convicted of actual voter fraud in an actual election, not just misunderstanding what they could or couldn't do. They cast votes for other people. One got 3 days in jail, the others got probation. So the disparity in the punishment and how the individuals are being treated also speak volumes. And with that, I will turn it over to Karla to pick it up and focus us on Georgia as a battleground state. Take it away.
Oh, thank you, John. Thank you, Jane. I appreciate the opportunity to be here tonight. My name's Karla Brenner, and I personally have been affected by the pre-clearance requirements. For those of you that don't know, I'm a state representative in Georgia and have been so for the last 24 years, and have been redistricted multiple times. I represent a majority seat, and post Shelby was impacted as a result of that. This is my friend Stacey Abrams, and I'd like to tell a little bit about her tonight, and her efforts against voter suppression in Georgia. And before my presentation, I think perhaps sounds a little bit, I don't know, we're going into, we are in an election year. And I just want all of you to know in advance that there is hope. We still get to vote. And whereas it may not seem like it's fair and just, we can't give up. So with that said, let me introduce you to Stacey. Stacey served in the Georgia House from 2007 to 2017. She was the minority leader from 2011 to 2017. And in 2018, she ran against now Brian Kemp for governor. She was so this occurred 5 years after Shelby. She was the first female major party gubernatorial nominee in the United States, and she lost the election by less than 55,000 votes, a race that many believe she would have won had it not been for racially motivated voter suppression. Abrams' opponent and the current Georgia governor, Brian Kemp, he served as Secretary of State during his gubernatorial run. And this shortly was before the pre-clearance requirements that were eliminated until 2 days after election in which he oversaw, right? So he ran for governor and he was the Secretary of State. One of the most controversial policies that Kemp enforced was the exact match. Under the exact match, if a new voter's application did not perfectly match the information in other government files, the Secretary of State could ultimately reject the voter's registration. Even a missing hyphen or a typo error could be attributed to a government employee. They could still eliminate the voter registration. In 2009, again, this is 2018, the election cycle, the pre-clearance requirements, the DOJ objected to Georgia's proposal and said that the exact match policy was retrogressive and erroneous, and it burdens voters of color. In 2010, Georgia modified this administrative policy, but fast forward, it was really unclear if Secretary of State Kemp implemented those safeguards. In the 2016 election, Kemp entered into a federal settlement with civil rights groups who had proved that his policy and practice had disproportionately prevented voters of color from registering in the last two election cycles. In 2017, right after the settlement, the legislative body, of course, rushed in to pass a version of the exact match policy, and which led to 53,000 suspended voter registrations, primarily for voters of color. So voters who could register struggled to remain on voter rolls in 2018, as the state purged more than 1.4 million Georgians from voter rolls. On a single night in 2017, Kemp struck down over 500,000 people, approximately 8%, and it was called the largest mass disenfranchisement in U.S. history. Kemp said that he was safeguarding the election from fraud. So not only did he purge voters from the rolls through the aggressive use of exact match, he also used something called use it or lose it law, so which permitted the state to use registered voters' decisions not to vote in recent elections as a trigger for removing them from rolls, even though they had been registered. So like the match procedures, the Justice Department had objected to similar prior proposals for use it or lose it under pre-clearance. Additionally, so purging voter rolls, Georgia changed its voting process in the years leading up to 2018. It closed polling places. It consolidated voting locations. Secretary of State Kemp then said, who is now governor of Georgia, because of Shelby, counties no longer needed to submit changes to the Justice Department for pre-clearance. As a result of precinct closures, the need to travel longer distance to vote likely prevented an estimated 54,000 to 85,000 voters from voting on election day in 2018. But there were more challenges. So you not only did you could have been purged, or you could have you could have shown up and maybe you asked for a provisional ballot, right? But provisional ballots, many poll workers didn't understand that the requirement, or they just refused to comply, or they ran out of provisional ballots. There was also problems in 2018 with absentee ballots, including the state's failure to notify voters, so they didn't have time to cure their ballot. So in the face of these systematic challenges, Stacey Abrams lost her bid for the governor's mansion. But you know what? She didn't give up. She formed a group called Fair Fight. She filed a lawsuit in federal court arguing that the cumulative effect of Georgia's voting system had been to deprive Georgia citizens, especially citizens of color, of their right to vote. Now, she ran again this past election cycle. She did not win again, but nevertheless, without preclearance, lawyers, advocates, and organizers redoubled their efforts ahead of the 2020 election, knocking on doors, registering voters, and continuing to challenge election practices in court. Next slide. So Georgia was ground zero for the 2020 presidential election. I personally can tell you that I received greater than 55,000 emails about Stop the Steal. And Stop the Steal really was what happened. It was the cumulative effect of what happened in the election cycle before January the 6th. And there's two names that I want you to pick up on here. There's after Governor Kemp, then you had Secretary of State Brad Raffensperger. President Trump called Secretary of State Raffensperger and said he just wanted to find 11,780 votes because we have won the state. It just went dark here, right? Did you see the light go off? Okay. That's the government operating. 11,780 votes. It stopped the steal. This election led to 2 U.S. Senate runoff elections in Georgia. For those of you that remember, Raphael Warnock and John Ossoff were elected the following in 2021, which tipped the balance in the Senate, along with President Biden, who won the election. I wanted you to see, this is a picture of what it was like. This was during COVID, and we're all there. Next slide. Protesting. The 2021 legislative session, the Senate bill 202. So Senate Bill 202 passed in 2021 after a record turnout in 2020. It is the most restrictive and dangerous anti-voter bill in the country. And it served as a blueprint for voter suppression bills nationwide. It imposed voter ID requirements. It criminalized handing out of food and water to voters in line, thus discouraging people from standing in lines. It placed unnecessary limits on ballot drop boxes. It also allowed legislators to take over county boards of elections and kick off. Remember Brad? It kicked off Brad, the Secretary of State, off the state election board because he did not find 11,780 votes. And to top it all off, it made filing mass voter challenges even more accessible. Next slide. So now we're in, after 2021, we had the Senate Bill 202 pass, which was Jim Crow 2.0. Now in 2024, we have Senate Bill 189, which made it easier for people to attempt to kick their neighbors off the rolls through voter challenges. Georgia already made voter challenges way too easy. Now voters in the state face an increased risk of losing their right to vote or being forced to defend it at public hearings. And election deniers, those that continue to say that the election was stolen, have had wide latitude to spread disinformation and waste election officials' time. So these challenges have been fueled by false claims about the election being stolen, including allegations that ineligible people voted, even though all evidence here in Georgia and across the country showed there was no widespread fraud in that election. In July of 2024, just one individual submitted two lists of around 34,000 voter challenges, alleging that these people had new addresses. Also in 2024, you had the state election board that came under national fire because they passed a series of rules that allowed local election officials to certifying elections. So I live in a blue county. So the county election board can, based upon not certifying an election in a blue county, which there's a few of in Georgia, allows this kind of delay. In August of, last month, President Trump, former President Trump, had a rally in Georgia, and three of the state election board members attended the rally. President Trump, former President Trump, did a shout out to all three of those members about how they have doing such an excellent job. Subsequently, in September, ethics charges were filed. The Georgia House Democratic Caucus and the Senate House Democratic Caucus filed a lawsuit, filed amicus briefs, and of course, we're in court again. So you should be asking, next slide, where do we go from here? In 2020, John Lewis died. This is a picture of where he lay in state in downtown Atlanta. As you can see, I have my mask on. It was still during COVID. Next slide. So this is where we go. As John Lewis and Stacey Abrams and others have demonstrated, vigilance is key. And lawyers and activists in Georgia and across the country still need to continue to fight for voting rights. So as John would say, do not get lost in a sea of despair. Be hopeful, be optimistic. Our struggle is not the struggle of a day, a week, or a year. It is the struggle of a lifetime. Never, ever be afraid to make some noise and get in good trouble, necessary trouble. Voter suppression has no place in our election, and I personally just want to say thank you for being part of this fight. Next slide. So as Dr. King said, the vote is the most powerful instrument ever devised by human beings for breaking down injustice and destroying the terrible walls which imprison people because they are different from others. So we have much work to do, and I appreciate all of you for being here tonight. Next slide.
And I think that's it. Said, I don't know if you wanted to chime back in to wrap up the hour. The rest of the slides are just a reference.
Just wanted to reserve my thank yous until the end for the most marvelous, informative, important presentation, considering where we are right now in history and the elections looming and all the problems we've got that are going on around us that we all are a part of. So this is an important presentation tonight, and I just want to thank you all again, Infinity, and I appreciate it so very much. And there's information if anybody wants to contact my colleagues. And thank you all for tonight, and we'll see you hopefully in October, October the 22nd. Let me triple check. October 22nd for our AI presentation. So thank you, everyone, and have a great night.